any of those communication issues.
So, you know, you've just asked a bunch of things, but it is funny because in the legal profession, we always joke that the clients want to be 100% protected and they want it to be one page. What they didn't tell us is the type size, right? So, you know, all right, I can do that, but the type size is going to be 1.
You need a microscope. A microscope.
So, you know, the contract we drafted for you is a very detailed, very thorough contract, right? But 20-some years of practice, almost 30, the problem is the lack of specificity in the contract. Projects that move forward with a bid, with a couple specifications, with a rough drawing, those always end in a disaster, right? The more detailed your contract, the better off for all of the parties. Now, oddly enough, this is something the homeowners don't understand. The contractors like a more vague document, generally speaking. The homeowners are protected by these large documents, but I've often found that when you present the homeowner with a large document, they get intimidated, right? They seem to want that picture of the house with a price next to it and nothing more. So yes, the detail in the contract is key. The lack of detail is what causes most disputes, right?
But let's clarify that real quick, because we have a lot of detail within the legalese or the verbiage of our contract, but are you specifically referring back to the specifications and the selections of the materials, the model numbers, all of the addenda, so to speak, that would come with the actual detailed scope of work with the list of materials being used?
Yeah, well, let's use your contract, for example, right? Your contract contains both. Your contract has what you would call the legalese, right? But there's a lot of important stuff in that legalese, which protects the parties by setting forth the parties' rights and obligations beforehand. So we know who has to do what and when. And so that's very helpful. Now that legalese relates to the other part of your contract, which is the various detailed plans and specifications and allowances, if that's the nature of the project. So yes, we have a sheet that has the allowances. Yes, we have a sheet that has the specifications, the materials we're going to build with, etc. But then we also want to talk about what happens when we decide to change the color, change the tile, the nature of the flooring, etc. And that's where that legalese comes in. And so I consider your contract the perfect combination, right? It's got a lot of legalese, as you would call it, but it has a lot of specification. Now, I didn't draft the specification because that is unique to each house, right? So that's up to you to make sure that that specification is in the right place, in the right form. But the contract as envisioned, when prepared, is a very thorough and protective document for all the parties involved.
Right. So the short answer is the easy road, whether that be from the client's perspective of a one-page contract with the price tag next to a picture of the house, which also would be easy for the contractor, is pretty much the worst thing you can do. Taking the time to plan up front and work through with the client all the details of the job, how things are going to happen, the timelines, the specifics on the materials being used, and really going through, instead of a one-pager, you might have a 9 to 10 page contract with another 9, 10, 12, 15 pages of specifications, so that everybody knows what's being used in the house and what's going to be installed in the way that it should look.
Yeah. One thing I think people don't grasp is, and this comes up all the time when I have homeowners in dispute with their contractor, is they don't grasp the nature of the relationship they entered into, right? We're talking about, if we're talking about somebody building their residence, right? We're talking about somebody's house. Right, so people generally have an emotional attachment to the house, and for good reason, right? It's very important to their life. It's where their children live, or grew up, etc., etc. So we have this concept with our house. We have this relationship with our house. Then we bring in this outside party to work on our house, right? And there's all kind of legal issues that can come up with that. And we mentioned the mechanics lien right. So if the contractor isn't paid, they may have lien rights against that property. What that means is it's not really easy to make your contractor go away, right? If there's a dispute, it can throw everything into limbo for the duration of the dispute. Maybe the house can't be finished for the duration of the dispute because maybe the house is the evidence needed for the dispute, and we don't want to complete it until it's been thoroughly inspected and photographed and looked at by expert witnesses, etc., etc.
So you could be camping in your house.
You could be camping in your house, right? Well, that's the description. So the concept of a good document with good specifications is to make sure that we're ahead of these problems that can come up, right? Because unlike your car mechanic, who you can just fire, unlike your your launderer, right, you can just not go to again, right? Once you're in that relationship with the general contractor, once they've come in your house and they've started working on your house, that relationship is almost, it's not a partnership from a legal perspective, right? But it is a partnership from a relationship perspective, because the homeowner and the contractor are tied together. And it is so important, like in a good partnership, in a good friendship, that you have trust in the other person. It's very important that you have that same close relationship with your contractor. And because you don't know this contractor before they walk through the door, a lot of that trust or ability to rely on them has to be contained in that contract, right? These are what your rights are. These are what your duties are. This is what I'll do for you. Obviously, in a friendship over 20 years, you don't have a list of duties and rights that's written down, but two friends know that, right? A husband and a wife may not have that written down, but it's an unspoken relationship. And you're bringing a contractor in, and it's going to be a very close relationship like that, but you don't have 20 years of establishing the rules, and that's what that contract is for, is to help establish the rules by which that very close relationship, a relationship that's very hard to sever in an instance, right? The rules by which that relationship will be governed.
Because, you even have, the guidelines from what meets a workman standards from the ROC perspective are basically as wide as the state of Arizona.
Right.
It's ridiculous. So they're there to protect the public, but you really, really have to do something wrong in order for that to come into play.
So the word there is minimum workmanship standards. Right. The ROC is looking for the minimum standard that's acceptable. So, the standards for a $75,000 house are certainly not the standard somebody building a multi-million-dollar property would like to see put into their property. Right. So,
but does the ROC distinguish between the two?
The ROC makes no distinction. Minimum workmanship.
Minimum across the board. When a homeowner's meeting with a contractor or intervening contractors, and we're talking about that level of relationship being created, it's really about the more time up front, the better. The more detail, the more conversation, the more planning, the more all of these things happen up front, which can be understandably frustrating for the client, because they're like, hey, I want to do my kitchen, or I want to build this house, and time is of the essence, and I got to be out of this house, or whatever it is. But the faster you move without doing due diligence and really getting to know someone, the greater the likelihood of having problems are, or dispute. But because the reality is stuff's going to go sideways a little bit on every project, right? Construction's not perfect. Maybe a little easier on a new build because you get the set of plans, and short of having unforeseen soil issues, but even with that, there's a lot of soil testing that goes into a house before you build it. But in the world of renovation, where you might be taking a home that's 1950, 60, 70, and then trying to bring part of it or most of it up to 2019, but still working within the shell. There's all kinds of things that'll come up that really nobody could account for, and certainly it wouldn't be a good thing for a contractor to account for all the things that could go wrong up front, because it would just inflate this bid to a huge number where most of it wouldn't go wrong. So it's really not if something's going to come up that's a challenge, maybe not necessarily a dispute, but things are going to come up, and so you have to be able to sit down and rumble through that with the contractor and the homeowner. And get a resolution to little things that will come up. So if you don't take the time to get to know someone up front, and really the more documentation the contractor can provide, the better. It's not the opposite. It's not lean and mean. The less there is, as far as the documentation and the specificity,
that's right. The worse it is in the long run. Right. So obviously the contractor can never draft around all potential contingencies with a 30-year-old house. You never know what you're going to find when you open the walls. Right. So you can have contract language that addresses how we're going to address that when it occurs, right? But yeah, it's the classic example of starting construction without knowing what you're building, right? And you get halfway through the project, and then someone decides they want a particular feature that requires you to undo stuff that's already been done. Well, now that's you're still paying for everything that's already been done. You don't subtract the price from the contract because you tore it out. That adds to the price of the contract, both the original installation and the tearing it out. And of course, these are issues homeowners don't necessarily grasp, right? And then,
Well, nor should they. I mean, they're not a professional.
that's correct. But you end up with this fight where the contractor's like, well, you should have told me that beforehand. With the homeowners telling the contractor, you should have told me that earlier. The contractor's like, well, you know, you're the one who wanted to go quickly, and it ends up in a very ugly situation. Now, generally at the ROC, the state will place the burden on the contractor, right? The problem is to get to get this resolution. Again, puts the homeowner's life on hold, and of course the homeowner has to file legal counsel for this fight, and there's costs involved there. And all of these problems can be avoided to a great degree with proper preparation, proper discussion about the scope of the work, and then proper documentation of what is going to be built and how we're going to deal with it, what you'd call legalese, if we deviate from the to-be-built plans and specifications. So I can't tell you, I cannot emphasize enough how happy I am with a nice big construction contract and a nice detailed set of plans. And you know, the lawyers, you know, 6 months down the road, a year down the road, when this dispute is in the hands of the lawyers, what they're going to be saying on the phone, that everybody was willing to go forward without knowing what was being built, it just makes the lawyer's case impossible to fight, right? What was to be built? There are no plans. There are no specifications, right? What was the price of this feature going to be that you verbally said was discussed, but didn't make it into any documents and doesn't have a price tag attached to it? Those are all the prime causes of disputes, right? You know, okay, something that's obvious. You pay the contractor and he takes the money and flees to Costa Rica. But that doesn't happen that often, right? Normally you have a...
Not with licensed guys, at least.
Right, not with licensed guys. Normally you have a contractor who's just moving a little too fast because the client wants it. Or the contractor's trying to please the client by putting the cart in front of the horse, by starting the project before the plans are finalized. But that, you know, unless the plans catch up,